Good morning, ladies and gentlemen. I have the privilege to chair this meeting, and the subject that we are dealing with is one of the most important subjects that concerns us. And to sum up in one sentence, my personal opinion, and I agree with my personal opinion, is that there are two sorts of international law. One international law that is applicable to the entire world, and then a specific international law that applies exclusively to Israel. But you came to hear them and not me. I was in government service for many years, and there are two sorts of ambassadors. You have distinguished ambassadors and extinguished ambassadors. And I belong to the second category. Now, at this time, I would like to introduce the first speaker, Abraham Bell, who is a professor of law at Bar-Ilan University and the University of San Diego. Professor Bell's scholarship focuses on property, international law, and economic analysis of the law. He has taught courses on each of these subjects, as well as copyright law, the laws of war, land use law, administrative law, tort, property tax, and legal aspects of the Arab-Israeli conflict. Among his notable recent publications is a critique of the Goldstone Report and its treatment of international humanitarian law, and the American Society of International Law proceedings forthcoming will publish this study. Professor Bell is currently working on the givings and takings of property, a book under contract with Yale University Press, co-authored with Gidon Parshamovsky, and a Israel Science Foundation funded study on NGO reporting on combat and international law during the 2006 Second Lebanon War, and this is in collaboration with Professor Gerald Steinberg. In 2006, Professor Bell won an Alon Fellowship for outstanding young Israeli academics. Professor Bell clerked for Justice Michael Cheshin of the Supreme Court of Israel between 1993 and 1994, as well as in the High Court of Justice Department of Israel's State Attorney's Office, 1994-1995. He has served as a visiting professor at the University of Connecticut Law School in 2008 and Fordham University Law School between 2003 and 2007. During 2008-2009, Professor Bell served as the director of the Global Law Forum at the Jerusalem Center for Public Affairs. Professor Bell is a senior fellow at the Center for International Communication at Bar-Ilan University. Professor Bell, the floor is yours.
Thank you very much for having me this morning. I presume that most of you have heard of the Goldstone Report. What I wanted to try to do is to tell you a little bit about why it is that we ought to consider this as a distinguished example of almost everything that goes wrong with international law and the laws of war. Now, for those of you who haven't heard of this, the Goldstone Report was a report put together at the behest of the UN Human Rights Council concerning the Gaza conflict of 2009. The head of the commission was Richard Goldstone, a justice from South Africa. He is here, the second from the right. Justice Goldstone was responsible for putting together the mission. That is, he chose the other three members. It came in at 575 pages, the final report, as it was initially published. It was after some edits, came out at 452 pages. It was, I think the joke was that it was a report that ensured by its length that it would never be read. If someone did take the time to read it, then they found a report that was shocking. It was shocking because it was clearly one-sided, procedurally defective, distorted the law, distorted the facts, and a broadside against the State of Israel. Now, eventually Richard Goldstone partially backed off of the claims in the report. On April 1st of this year, no April Fool's joke, Richard Goldstone published an op-ed in the Washington Post in which he said that we now know a lot more than we knew then. If I had known then what I know now, the report would have come out a quite different document. He partially apologized. The Israeli military did not target civilians as had been falsely charged in the report. Hamas actually is a terrorist organization, something that he forgot to mention in the report, and so on and so forth. There was, of course, a little pushback from other members in the mission. More or less, the other three members in the mission stated that there's no justification for taking back any of the report. Whatever the facts may be, there's no UN procedure that allows us to recognize that the report might have been wrong. And what's more is we worked very hard at writing the report, and so therefore we must stand by the conclusions. Now, why is this entire sad and sorry episode of a report of relevance to us? Well, it's of relevance to us because of this. It is a tool in an ongoing battle to engage in waging of lawfare. That is diplomatic warfare by means of legal terminology and legal institutions against the State of Israel. And so, citing the Goldstone Report, various pro-Palestinian activists have sought to have Tzipi Livni arrested, Shimon Peres arrested. This was, by the way, the same week as Justice Goldstone published his report, his op-ed in the Washington Post. And even now, after Justice Goldstone published his whoops, I didn't mean it, still you have threats of legal cases, criminal arrests against Israelis. This one concerns Yochanan Lacher, who was apparently, according to at least the Turkish Weekly, did not travel to the UK for fear of being arrested for alleged crimes proved by the Goldstone Report. Now, there's three lessons that we ought to draw from this episode, I think. And they are this. International law may say all sorts of nice and kind things, but at the end of the day, international law can and will be manipulated for political ends. International law does not arise and does not get applied in the abstract. It gets applied and used through institutions. These institutions have their own agendas. These agendas may not be friendly, and they may not, in fact, serve the interests of that are we want to be served by international law. We have to recognize that in dealing with international law, which brings us to the last point, which is when we're dealing with issues of international law and the laws of war. There are two totally separate challenges that we face. One of them is to have a set of legal rules that will govern our own conduct. And this may or may not have anything to do with the legal standards that exist in international law. There's a second challenge, which is divorced from that, which is irrespective of the way we've acted. Whatever the legal standards may be, we have to remember that someone out there will take the legal tools that we have carefully crafted and distort and manipulate them as part of an ongoing diplomatic war. And we have to be prepared for that as well. It is not sufficient simply to cry foul and say it's not fair. It's not fair, but it's inevitable. All right, so let's talk. I wanted to start with the first point here, the ways in which it can and will be manipulated. And I think in this, the Goldstone Report provides us with many, many nice examples of how international law, whatever the rules may be in the abstract, can and will be manipulated for political ends. So one example of the way the Goldstone Report did this, and the way others do it, is by simply omitting those portions of international law which are inconvenient and do not serve the agenda of the writer of the report. So here we have, there's this extensive body of international law that has to do with terrorism. It forbids, among other things, it requires states, to criminalize the financing of terrorism, to bring criminal actions against not only those who finance it, but if you look further on, those who organize or direct others to commit such offenses, who participate as accomplices, in general engage in all sorts of activity that is in connection with a group acting with a common purpose. So this would say, for example, that a group like Hamas, which engages in acts of terrorism as they're defined in this treaty, right? That is, acts intended to cause death or serious bodily injury to a civilian or other person not taking an active part in hostilities, when the purpose of the act is to intimidate a population. Right? So any member of Hamas, so long as they're doing their acts within Hamas with, as part of a group of persons acting with a common purpose, furthering the criminal activity and knowing that the group intends to commit the offenses, has committed a crime, and the signatories to this, the parties to this convention are required to bring charges against such persons, right? They must establish as criminal offenses and make those offenses punishable. Now, you have similar treaties. This is not the only one, the treaty against terrorist financing. You have conventions against the suppression of terrorist bombings. Here, too, again, you have a clear definition of what it means to be engaging in forbidden terrorism. And once again, it requires states to bring charges. Now, in addition to the fact that most states in the world are parties, overwhelmingly, most states in the world are parties to those treaties and therefore have legal duties to act against terrorist organizations, we have Chapter 7 resolution of the UN Security Council. Security Council Resolution 1373 requires states to refrain from providing any form of support, active or passive, to entities or persons involved in terrorist acts, to deny safe haven to terrorists, to take the necessary step to prevent commission of terrorist acts, etc., etc. A variety of steps that all states that are members of the UN, that is, all states, must engage in against terrorism. Now, this is obviously relevant to the conflict between Israel and Hamas. Right? It has to do with what are the legal duties that Israel has to criminalize Hamas. It also has to do with the nature of the persons that can lawfully be targeted as part of Hamas. Now, there's other ways in which Hamas is a criminal organization. It engages fairly explicitly in incitement to genocide, which creates its own set of legal duties. But let's leave that aside for the moment. Let's just focus on the question of terrorism. How many times did the Goldstone Report actually mention that there is any international law of terrorism? Not a single time. It simply does not serve the agenda of the report. How many times did it acknowledge that Hamas is a terrorist group? Not a single time. And how many times did it conclude that it engaged in acts of terrorism? None. So one way in which the Goldstone Report, and I'm sorry to say this is not atypical. One way in which the Goldstone Report manipulated the law was by simply omitting the parts that were inconvenient to it. Now, once it got to the parts that were convenient to it, it decided to, and again, this is fairly typical, misstate and misapply the legal standards. So I'll just give you an example which is related to the one we just spoke about. Right? There's a rule in international law that one may not engage in collective penalties or what are called collective punishment. The meaning of this legal rule is fairly clear. This is how it's described in the abstract by a publication of the ICRC. It is basically an application of the rule that no one may be convicted of an offense except on the basis of individual criminal responsibility. In other words, one may not impose criminal penalties on those that have not themselves committed a crime. But that's not the way the Goldstone Report sees it. The way the Goldstone Report sees collective punishment are actions that the Palestinians feel are a form of collective punishment inflicted upon them because of their political choices. Political choices here is a euphemism for the selection of Hamas, the terrorist organization, to take power in the Gaza Strip. Now, the result, therefore, says the Goldstone Report, and this is shocking, Israel is committing collective punishment by engaging in economic and political sanctions against the Gaza Strip. Now, if you go back a moment to what it says in Security Council Resolution 1373, Israel is not merely permitted but required to engage in certain kinds of economic and political sanctions against Hamas and Hamas government in the Gaza Strip. That is the result of the requirement that it refrain from providing any form of support, passive or active. But in the Goldstone Report, this is flipped. In the Goldstone Report, obeying international law becomes the violation of the rule denying the right to commit collective punishments. Here's another distortion. There's a basic set of principles in the law of armed conflict that derives from this a moral theory of Thomas Aquinas. More or less it has to do with acts that have a double effect. If I intend to do something and I know that this action that I'm about to do is going to have good and bad effects, then when is it moral for me to undertake this action? We can more or less boil down Aquinas' theory to something like this. I may undertake the action if I aim at the good and I know that the good outweighs the bad. And this is more or less the way it's phrased in the laws of war. Right? I must aim at the good, distinction. I must aim at combatants or objects that contribute to the military effort. And I must do so where I anticipate that the good will outweigh the bad, that is, there won't be excessive collateral damage. But this is not the way the Goldstone Report sees it. And the way the Goldstone Report sees it, aiming at combatants is unlawful if Israel is doing it, because combatants on behalf of Hamas are in fact civilians. Right? The so-called Gaza police, the interior security forces for Israel, are simply civilians. They are immune from attack. What's more is that even where Israel aimed at the right thing, says the Goldstone Report, every time that an Israeli attack resulted in the death of a civilian, it must have been a war crime. Why? Because no errors occurred, according to the Goldstone Report, and therefore, the only way that they could have resulted was from deliberate planning and policy decisions throughout the chain of command. So if you find a dead civilian, then Israel must have violated both the rules of distinction and proportionality, must have aimed at the civilian because no errors could possibly have occurred, and it must have anticipated this civilian death as a disproportionate outcome. All right. Now, even once the laws were distorted, the Goldstone Report could manipulate the facts. And again, this is sadly typical. Right? So we have numerous newspaper reports having to do with Hamas's hijacking of hospitals as military bases. This is clearly a violation of the rules of war. It's an act of forbidden civilian shielding and of perfidy. The Goldstone Report had to somehow or another deal with this, and this is the way it dealt with it. The mission did not investigate the case of Al-Shifa Hospital on the basis of the investigations it has conducted, that is, zero. The mission did not find any evidence to support the allegations made by the Israeli government. So, in other words, we know it didn't happen because we didn't investigate it. Since it didn't investigate it, therefore, there's no proof of it. It must not have happened. What about where there were allegations against Israel? There, not only did the Goldstone Report investigate, it had to invent the facts in order to fit the conclusion. So one of the accusations made was that Israel had deliberately conducted airstrikes on January 9th against a flour mill in order to disable the factory's productive capacity and deprive Gazans of flour. Unfortunately, there happened to be aerial photos of this. So here you are on January 11th. The roof of the flour mill is inconveniently intact. Right? How did that manage to happen if it was struck by airstrikes? Well, never mind that, says the Goldstone Report. The nature of the strikes and the precise targeting of crucial machinery on one of the mid-level floors suggests that the intention was to disable its productive capacity. That is, not only did they invent the airstrikes that never occurred, they invented the state of mind accompanying the Israeli imaginary attack in order to find that Israel committed a war crime. Now, let's move on to then, what do you do with all of this stuff? As I said, in the end of the day, when you're talking about international law, you're talking about the institutions that implement and interpret it. And so Hillel Neuer, I believe, spoke to you yesterday about this particular institution, so I won't talk about it too much, but I'll just mention that when you're talking about things like the Goldstone Report, it's not simply the UN Human Rights Council, which has an abysmal record on Israel, that was ready to endorse these distortions of international law. The EU Parliament was perfectly willing to endorse it and is still refusing to back off its prior endorsement. That is, no matter how the international law has actually been distorted, it will still be possible to find institutions that will utilize and distort utilize the report and, as a result, distort international law. And so then what does this tell us about what we ought to do? And again, what this tells us is something quite simple. International law does not do the work on its own. International law does not get applied in the abstract by angels. It gets applied by actual institutions in the real world. And so when we are discussing international law, we have to remember that it is all fine and good for our own standards to establish the rules of conduct by which we will be conducting ourselves. But as we see international law playing into the world, we have to understand that it will be utilized by institutions that are unfriendly. This is the way the numbers of democracies line up in the world. And we should not be so naive as to believe that law is self-interpreting. Thank you.